Hello viewers, I am Professor Sharanjeet, working at the Rajiv Gandhi National University of Law, Punjab. In today's lecture, we shall talk about the prison reforms in India. As with Western countries, the conditions of the prisons in India was not very good. There was no formal prison administration in the country. There is a reference to prisons in the Vedic period in the important Hindu scriptures as well as during the Muslim rule in the country. However, there was no formal structure of prisons during those times, and punishment meant physical torture and inhumane treatment for the wrongdoer to set an example for the rest of the population. The East India Company came to India primarily as a trading company, but with the passage of time, the British established a huge empire in India. The British rulers enacted different laws to rule the country in a better way. One such important piece of legislation was the Indian Penal Code 1860. Reference to the Indian Penal Code 1860 is imperative as it opened the gates for a formal prison structure in the country. Lord Macaulay's Indian Penal Code 1860 helped in formalizing the concept of prisons in India. The reason behind this is that in the Indian Penal Code, imprisonment as a mode of punishment was provided for a large number of offences. And for this purpose of incarcerating the wrongdoers, the prison infrastructure was also required to be created. Thus, the Britishers started constructing more prisons in India for the purpose of incarceration. It is interesting to note that even in the very significant Committee on Prison Reforms, that is, the Mullah Committee, formerly known as the All India Committee on Jail Reforms 1980-83, it was also stated that our contemporary prison administration is a legacy of the British rule. A reference was made to Lord Macaulay's statement when he said, "Imprisonment is the punishment to which we must chiefly trust. It will probably be resorted to in 90 cases out of every 100. The British had set up various commissions and committees to formalize the prison structure in India as well as bring about the required prison reforms. The first Commission on Prison Discipline 1834, this report is also called the Lord Macaulay's Commission Report. In this report, Lord Macaulay emphasized the need that the best criminal code can be of very little use to a community unless there is good machinery for the enforcement of punishment. The major recommendations of this report were better classification of the convicts, separation of convict prisoners from the under trial prisoners, abolition of outdoor labor, introduction of indoor work for the inmates, and employment of inspectors of prisons. Next was the Prison Discipline Committee of 1836. This important committee submitted its report in 1838. The major observations made in this report were that there was rampant corruption in the prison establishments, laxity of discipline, and the system of employing prisoners on extramural labor. The committee recommended increased rigorous treatment and rejected all notions of reforming criminals through moral and religious teachings, education, or any system of rewards for good conduct. This committee also proposed the establishment of the Office of the Inspector General of Police. Another significant recommendation was the separation of the under trial prisoners from the convict prisoners. Next is the First Jail Reforms Committee of 1838. The major recommendations of this significant committee were as follows: better conditions to live inside the prisons and the appointment of a prison inspector in every state whose duty was to inspect and examine the administration of jails in that particular state, and the constitution of a central jail where the prisoners who were given imprisonment for more than 1 year were to be lodged. The capacity of the central jail was recommended to be around 1000 prisoners at a time. Next, we move on to the Second Jail Reforms Committee of 1862. The chief recommendations of this committee were as follows: the need to classify the prisoners on the basis of the nature of the offence committed by them, the appointment of medical officers in each central and district jail, and better medical facilities for the inmates, better provision for residence, food and clothes for the prisoners, and importantly, a provision for keeping 15% of the prisoners in solitary confinement in each central jail across the country. The Second Commission on Jail Management and Discipline 1864. This commission also tried to improve the condition of the prisoners with regards to food, clothing, shelter and medical facilities inside the prisons. This commission also fixed the required minimum space for every prisoner at 54 square feet and 640 cubic feet. The third commission was established in Calcutta in 1877. Dear viewers, a conference of experts took place in 1877 in Calcutta to look into the aspect of prison administration in India. One of the most prominent recommendations of the conference was the enactment of a new prison law, which would in turn help in bringing about uniformity across the prisons in the country. The Fourth Jail Commission in 1888, in concurrence with the Third Commission at Calcutta, also recommended the enactment of a single prison law. In order to provide better health facilities to the prisoners, this commission also recommended the setting up of jail hospitals. Next is the Indian Jail Committee 1919-20. This committee talked about reforming the criminals during the period of their incarceration. This committee observed that when the prisoners are in jail, the objective is not only to stop them from committing offences in the future, but also to reform their character. The major suggestions of this important committee were as follows: the need for the classification of the prisoners as hardened or habitual criminals from the casual ones, solitary confinement should be avoided and prisoners should be kept together. The object of imposing labor on a criminal should be for the purpose of reforming him. We need to abolish flogging in prisons. The offenders should have the right to receive and write letters during their prison lives. In order to maintain social contact with the prisoner, he should be allowed to meet his family. Provision of liberties in the prisons. The criminal should be provided with 2 pairs of clothes. The quality of the food should be good. Separate institutions for young offenders in the form of juvenile homes should be established. After release from prison, the prisoner should be assisted in rehabilitating in society with his family. Implementation of the payroll system in order to maintain societal ties with the prisoner. freedom to study for inmate below 25 years of age. The convicts who were punished for more than 6 months should be given some privileges inside the prison. The gatekeeper of the jail should be a literate person only. In order to ensure medical facilities for the inmates in every jail, the resident doctor of the jail should be appointed. Importantly, the jails should be looked after by trained officers only, and the jailer should be a person who is experienced in jail administration. Instead of a police officer, a doctor in the army should be preferred. Next is the Jail Reforms Committee of 1946. The main recommendations of this pre-independence committee were as follows. We need to treat juvenile offenders differently from the adult offenders. Classification of the offenders into different categories on the basis of gender, age, habitual offenders, casual offenders, and mentally unsound offenders. This committee also gave suggestions with regards to the construction of modern prisons across the country, recruitment, selection and training of prison officers, discipline among the prison officers, including the daily routine and education of prisoners, vocational training, aftercare and rehabilitation of the prisoners, proper recruitment, selection and training of the prison officers. Dear viewers, now we shall come to the prison reforms in India post-independence of the country. Before we start with the post-independence initiatives for jail reforms, it is important to quote Mahatma Gandhi ji. Mahatma Gandhi ji strongly favored sympathetic treatment for the jail inmates. He had stated that prisons should be changed into hospitals to give treatment to the offenders, to bring them on the correct path. An officer of the jail should be changed into a doctor. The offenders should feel that the officers of the jail are their friends. One significant development post-independence for the country was doing away with the punishment of transportation for life. The punishment of transportation for life was substituted with imprisonment for life. During the British rule, cellular jails were built in Andaman and Nicobar Islands, where freedom fighters were often transported. The punishment of transportation of life was very inhumane, as the prisoner lost the chance of returning to his family and society forever, and the incarceration was in a very inhumane condition. In the Constitution of India, jails or persons detained therein are a state subject under entry 4 of list 2 of the 7th schedule to the Constitution of India. That is, the administration and management of prisons and prisoners are the responsibility of the respective state governments, which are competent to take appropriate action in this regard. Post-independence, the first committee that was constituted to look into prison reforms was the Pakawasha Committee 1949. This committee allowed the prisoners to take on work in making roads in the country, and for that wages were also to be paid to the prisoners. Dear listeners, now we will discuss the contributions of Dr. Sampurna Anand with regards to prison reforms. Dr. Sampurna Anand was a great social reformer, thinker and philosopher, and he introduced the concept of open prisons in the state of Uttar Pradesh. The open prisons were more rehabilitative in nature, where the inmate could live a more social life, which helped him adjust to the outside world better after his release from the prison. In the open prisons, the prisoners could move freely, indulge in work and be paid wages for the work they did. Next important work was done by the Reckless Commission report of 1952. Dr. W.C. Reckless was a United Nations expert on correctional administration. The Government of India invited technical assistance from the United Nations. Dr. W.C. Reckless visited India and gave many suggestions for improving the Indian prisons. His report is entitled Jail Administration in India. The major recommendations of this report were a reformative approach to jails, the setting up of new jails across the country, and different procedures for juvenile delinquents. He strongly recommended the revision of outdated jail manuals and the introduction of legal substitutes for short sentences. Periodic revision of the jail manuals in the states and the establishment of state aftercare organizations in every state. Creation of a Central Bureau of Correctional Services at the center. The correctional services are to be integrated together under the supervision of a director or commissioner under the control of the Home Department in each state. With this, we come to the next committee, that is the All India Jails Manual Committee 1957 to 59. The Government of India appointed this committee to prepare a model prison manual. The observations made by this significant committee were that the prison institutions should be centers of correctional treatment, where major emphasis should be given on the reformation of the offenders. The impact of the institutional environment and treatment shall aim at producing constructive changes in the offenders as well as having a profound and lasting effect on his habits, attitudes, approaches, and total values of life. The major recommendations of this committee were that the prison should be effectively managed with an emphasis on correctional administration, rehabilitation, and reformation of the wrongdoer. Dear viewers, next we come to the All India Committee on Jail Reforms 1980-83. This committee is popularly known as the Mullah Committee because the chairman of this committee was Justice Anand Narayan Mullah. This committee is considered to be a very significant one with regards to prison reforms in India. The Mullah Committee gave detailed recommendations for the purpose of better correctional administration in the Indian context. And the major recommendations of this committee were as follows. The living conditions inside every prison should be dignified by taking note of proper accommodation, hygiene, sanitation, food, clothing, and medical facilities for the inmates. In order to maintain social contact with the prisoners, the mechanisms of parole, aftercare, rehabilitation, and follow-up with offenders should become an integral part of the correctional administration in the country. Keeping in mind the best interests and to meet the objectives of punishment, new alternatives to imprisonment such as community service, forfeiture of property, payment of compensation to the victims, and public censure should be added. The committee recommended that the Probation of Offenders Act 1958 be effectively implemented throughout the length and breadth of the country. With regards to the under trial prisoners, the committee gave a detailed recommendation that the state evolve a proper mechanism to ensure that no under trial prisoner is unnecessarily detained. The committee also recommended that there be in each state and union territory a Department of Prisons and Correctional Services dealing with adults and young offenders, including institutional care, treatment, aftercare, and other non-institutional services. Most significantly, the committee recommended that the government recognize that the process of reformation and rehabilitation of offenders is an integral part of the total process of reconstruction and therefore devise national development plans in this regard. In order to bring about the desired results in the correctional administration, funding is another cardinal aspect, and in this report, the committee had suggested that the government at the center and in the states and union territories make efforts to provide adequate resources for the development of prisons in the country. The committee also recommended that the development of prisons be planned and systematic, keeping in view the broader objective of correctional administration. Another significant recommendation of this committee was with regards to setting up more open prisons across the country. The committee also recommended that the prison service be developed in a better way, and the state government should make efforts to develop a well-organized prison cadre based on appropriate job requirements, proper training, and proper promotional opportunities for the staff. With regards to the women prisoners, the National Committee on Women Prisoners 1987 was constituted. This committee is popularly known as the Krishna Iyer Committee. Before discussing the recommendations made by this committee, it is important to refer to the observation made by Honorable Justice Geeta Mittal. She observed, "The marginalization and discrimination experienced by women in society do not stop at the prison entrance. Rather, it continues to impinge on their lives even when in state custody, perhaps in its most aggravated forms." The major recommendations of this committee were that women prisoners should be informed about their rights under the law. Whenever a woman prisoner had to be searched, the search shall be done only by a woman constable. Similarly, the medical checkups of women prisoners shall be done only by female doctors. Women should be allowed to keep their small children with them. In order to keep social ties intact, women prisoners should be allowed to meet their families, social workers, and voluntary organizations, and a special prosecution officer should be available to present the case of the women prisoners. A latest committee on prison reforms is the Justice Amitva Roy Committee on Prison Reforms 2018. Dear viewers, in 2018, the Supreme Court of India constituted a 3-member committee to look into issues of reform in prison administration in the country. The main objectives of this committee were to study the prominent problems in the Indian jails, reasons for violence in the prisons, unnatural deaths in the jails, medical facilities in the prisons, training of the prison management staff, to examine and recommend measures for children in observation homes or places of safety under the Juvenile Justice Care and Protection of Children Act 2015, and also to recommend steps for the psychological well-being of minor children of women prisoners, including their education and health. The main recommendations made by this committee are as follows. The Amitva Roy Committee has recommended mandatory segregation of under trials, convicts, and first-time offenders inside the prisons while producing them before the court, during their hospital visits, etc. The committee also recommended that the prison administration strive to comprehensively implement the national and state health insurance schemes such as the Ayushman Bharat scheme, the Chiranjeevi health insurance scheme, and similar state health insurance schemes in the prisons. The committee also suggested the need for a robust grievance redressal mechanism for the prisoners to register their complaints. In order to reduce the overcrowding in prisons, the committee recommended that special fast-track courts be set up to extensively deal with petty offences and cases pending for 5 years or more. The committee recommended that, as far as possible, protection of senior citizens and sick persons in jails should be done through the help of video conferencing. In order to prevent unnatural deaths among the prisoners, the committee recommended steps to avoid suicides by hanging in the prisons. The panel observed that it was the worst violation of human rights. The committee recommended that the prison infrastructure be such that any suicide bid by the inmate does not succeed, for instance, through the use of collapsible material. The committee said that the jail staff should be regularly provided with the requisite training to recognize signs of depression among the inmates and also to implement the National Legal Service Authority's guidelines to strengthen the under-trial review committee mechanism. The committee noted that only 13 states and 2 union territories have designated a complaint officer to deal with complaints of violations of the rights of transgender inmates. The majority of the states and the union territories have not formulated welfare schemes for the transgender prisoners. In the end, I would like to say that, as discussed today, the committees that were constituted after the independence of the country have focused more on the modernization of the Indian prisons. With this objective in mind, a scheme known as Modernization of Prisons was implemented in the year 2000 for a period of 5 years in 27 states with an outlay of Rs 1800 crores. The cost was to be shared in the ratio of 75:25 between the central and the state governments respectively. In the end, I would like to emphasize that the prisons across the world have actually come a long way from being only gaols, penitentiaries or karagrahas to the modern correctional institutions. With this, we come to the end of today's lecture. Thank you very much.